This is PDF page.
Volume 1A. Volume 1.
Volume 1A, look. Volume 1A.
Volume 1A.
Lord, it is a daunting task to appear before the 9 judges of this court, Lord. But then it is made more daunting by your Lordship's insistence on the paperless proceedings. Lord.
You realize how simple it is. It cuts down on time, and it's so it's so streamlined for all of you because you can switch from
I don't know,
file to file.
Maybe not at your Lordship's age, perhaps, and not it's easier. But a person of my age, it becomes a little more difficult.
What are you saying, David?
Have Lordship have my written submissions?
Yes.
Volume 1A. But the issue involved in this case is primarily concerning states' jurisdiction over industrial alcohol or rectified spirit, or short, IA, industrial alcohol. And this rectified spirit is also called ethyl alcohol as an alternative. In synthetic second case, it was, that is 1990 Supreme Court, it was categorically held that rectified the denatured spirit is industrial alcohol and is outside state's jurisdiction under Entry 8, List 2 of the 7th Schedule to the Constitution. Entry 8, List 2, when it refers to intoxicating liquor, deals only with potable alcohol when it is had as it is. Synthetic 2 further went to the extent of denying jurisdiction to states in relation to industrial alcohol, even under Entry 33, List 3, as product of a notified scheduled industry under the Industrial Development Regulation Act, hereinafter referred to as IDR, namely declaration by Parliament under Section 2 of the IDR Act, read with Section 18 of the IDR Act, covers the entire field, ousting states' jurisdiction. The sole issue broadly is whether states have legislative jurisdiction to deal with and regulate industrial alcohol, as well as the expanse of it, whether the jurisdiction is exclusive or concurrent. Synthetics 2 is erroneous on both the counts. It is for this reason that the reference order of the Constitution Bench dated 8/12/2010 doubts the correctness of it after meticulously examining the judgment. The state's jurisdiction over industrial alcohol can be exercised in two ways. A, state has jurisdiction and control over industrial alcohol under Entry 8, List 2. Or, states have jurisdiction in respect of industrial alcohol under Entry 33, List 3 as product of notified scheduled industry under IDR Act. And the field is unoccupied. This is a statement which lots of mark, not that the field is unoccupied. Because Entry 33, List 3, question of occupied field will arise. Intoxicating liquor, I'll come to this, then kindly have questions. I have framed for your audience's convenience the questions. Page 29, lots of I have framed. License claim. But I've got down to
Question.
Page 29 of the volume 1. Page 29, of volume 1 itself, so Lordship would have the questions. Whether state can regulate and control industrial alcohol Page 29.
Page 29 of volume 1.
Ah. It's page 29 of volume 1A, same volume. Questions for consideration. Whether state can regulate and control industrial alcohol, commonly called rectified spirit, of more than 95% V by V, including denatured spirit. This has two aspects. A, one, whether industrial alcohol is included in entry 8 list 2 and is therefore within its exclusive jurisdiction and control. Or two, whether it falls under entry 24 of list 2 and therefore can travel on to entry 52 of list 1 on specification of fermentation industry as a notified industry under Industrial Dispute Development and Regulation Act. Not this question, if I may not pause for a moment and elaborate a little more. Entry 52 list 1 is the entry under which IDR Act was issued in the year 1951, enabling the center or the union to specify which of the industries it wants to take over. Now, entry 52 is intricately linked with entry 24 list 2. Lordship would have entry 24.
We'd like to just sort of show us the entries so that we can
I'll
at
come
the
to that.
outset.
I'll come to just
Let's
for
look at the entries first, so that the whole thing turns in on the construction of the entries in this case.
Quite right.
So let's look at the different entries which are involved. That's the best way to go about it. Then we'll of course read your questions.
The first entry to be taken into consideration is entry 52, list 1. This is where the synthetics 2 had placed industrial alcohol. Because IDR Act comes in and fermentation industry was notified in the year 1956 under the schedule to the IDR Act, implying thereby that the declaration under IDR Act would apply and this industry is abstracted from entry 24 list 2 and goes on to entry 52 list 1. So once a declaration is made, entry 52 comes in operation. Otherwise, entry 52 list 1 has no, it's a shell, it is inoperative unless there is a declaration. See, if I may place entry 52.
Yes.
Industries, the control of which by the union is declared by Parliament by law to be expedient in the public interest. So what it implies is not those industries where the union feels that the control should come to the union and the Parliament has to declare it by law. That law will indicate the extent of control it wants to take over also. And that industry to that extent comes over to. But importantly, along with 52, Lord, if I may juxtapose entry 24 list 2. Because we can't understand entry 52 list 1 without looking into entry 52, entry 24 list 2. 24 is industries subject to the provision of entries 7 and 52 of list 1. So there is an inherent link between entry 52 list 1 and entry 24 list 2. Industry as a subject originally belongs to the state jurisdiction. Just for a moment, keep out the IDR Act or the declaration.
Entry 24 is subordinate to entry 52 of list 1.
No difficulty. It is. There's no doubt about it. It's subject to. But what I'm saying is let us for a moment, for the purposes of analysis, take out the IDR Act or the declaration. Then what conclusion that comes to the fore is that entry 24 is the basic entry where state has jurisdiction over industry. Now that word industry transports to or gets transported to entry 52 on a declaration by Parliament. If
It's not like
Parliament
that.
makes a declaration,
No, actually entry 52, entry 24 of list 1 of list 2 is made subject to entry 52 of list 1. Entry 52 of list 1, which gives the dominance to a parliamentary law, is provided Parliament has made a declaration in a law. under
provided.
entry 52.
That's what I'm saying. Not unless there is a declaration, the jurisdiction rests in the state.
Obviously, if
That's the point.
but right, but once the declaration is made under entry 52
Then that part
law,
which is taken over goes to the union.
one further very interesting thing is, look at entry 54 in contrast to 52. I mean, we were dealing with entry 54 just 2 weeks ago.
Yes.
Regulation of mines and mineral development, to the extent to which regulation and development under the control of the union is declared by Parliament by law to be expedient in the public interest. Now, the words "to the extent to which" are interestingly absent in entry 52.
There is a reason.
So once Parliament makes a declaration, in this, as in this case under section 2, the entirety of that field of that industry is within the control. It's not to the extent to which.
I'll answer that question. Note that question has very frequently arisen and lots of have answered it in a number of occasions. Note the word 54 here, if you Lordship would once again have a look at 54, there's a difference in the two entries. Regulation of mines and mineral development, to the extent to which such regulation and development under the control of the union is declared by Parliament by law to be expedient in public interest. Now the word "to the extent to which" has been used for an obvious reason. Word not here, the entry 54 includes both the manufactory, that is mines. That's the factory part, the manufacturing part, and includes mineral. So there's nothing else there left. So both the things come over here on a declaration. Unlike industries, when a declaration is made, the product of the industry doesn't go there. Here, the product of the industry is taken over under entry 24. But in case of industry, entry 52, your Lordship may have entry 33 list 3.
Takes complete control.
So it's not that the whole industry goes over or everything goes relating to that industry goes over. Kindly have entry 33 list 3. So we'll have to consider what is the ambit of the word industry. And that will have to be assessed first and foremost in the context of the state entries. The reason being, entry 24 is intricately linked with entry 52 because whatever can be drawn under entry 52 is from entry 24 and no other entry. Then kindly have 26 and 27. Entry 26 and 27 of list 2.
Actually, just dwell on entry 33. You can read entry 33. That might help you.
Very well. Trade and commerce in and the production, supply and distribution of the products of any industry where the control of such industry by the union is declared by Parliament by law to be expedient in public interest, and imported goods of the same kind as such product. So therefore, trade and commerce, supply and distribution don't go to entry 50.
So it's very interesting because once a declaration is made by law of Parliament under entry 52, the trade and commerce is taken out of the field of entry 52 and immediately goes into entry 33 of list 3.
As product of the notified industry.
Right. So to the extent, therefore, regulation of trade and commerce, production, supply and distribution, this goes into the concurrent list.
Concurrent list.
The law made then by the state legislature can be overridden by a law which is made by that's Article 254.
There is no difficulty. I'll say, as I said.
But entry 33 is an indication that notwithstanding a declaration which is made under entry 52, a law made by Parliament under entry 52 of list 1, subjects still lie in the province of the states, albeit under the concurrent list.
Yes.
Namely trade, commerce and
now, importantly,
supply and distribution.
Now, importantly, since Lordships have noticed this, kindly come to the state list again.
So in other words, the domain of entry 52 will be everything pertaining to that industry minus NT 33.
Yes.
Understand. And it will be more apparent if you lordship.
Carving out an exception.
Yeah, absolutely.
Now,
Entry 33, list 3,
Fine.
it carves out an exception within the domain of entry 52, list 1.
yes, lordship is right, Lord, because then now trade and commerce, supply and distribution would not come under entry 52, list 1, even if it is a notified industry. Now, but before I proceed further, kindly have Lord once again come to the state list. List 2, entry 24. And if your lordship would permit me to elaborate on this, Lord, that I think would become clearer.
Which entry?
24. Once again, Lord. Industries subject to the provisions of entry 7 and 52. Now, we are not concerned with 7, Lord, we are concerned with 52 of list 1. So, in other words, lordships are right when lordship said, Lord, that it is subject to, therefore subordinated. Now, Lord, the important part is kindly see entry 26. State list.
Entry
26.
26.
Trade and commerce within the state, subject to the provisions of entry 33 of list 3. So the trade and commerce in the product of the industry is still in the state list. I'm saying for a moment, imagine that there's no IDR or entry 52. Then what is the position? The industry.
Then entry 26, list 2 would be subordinate to entry 33, list 3.
That's accepted, no? I would accept that. There's no doubt about it. Then 27 again, entry 27. Entry 33 is the combination of these two entries, 26 and 27. Entries दिखा रहा है.
We tried fast.
Now, let me again explain it from the ground level, which is the state list. Now, state list contains 3 entries, lordships have seen, industry, which is basically state subject. Then the the trade and commerce and the production and supply do not fall in the word industry because there is a separate entry for that, 26 and 27. So 26 and 27 will never come to word industry. Now, when the IDR Act makes a declaration with regard to any industry, there are a couple of questions that will arise. One is, what will IDR Act take from the state list, the declaration? It will only draw from entry 24. It can't take over from entry 26 and 27 because that goes to entry 33. The product of the declared or a notified or scheduled industry doesn't fall in entry 52, but goes to entry 33.
Right.
Now the question is what?
So therefore, the entire doctrine of occupied field may not then be applicable to entry 52 of list 1, because on the face of the entry, a certain field, notwithstanding the declaration under entry 52 of list 1, falls under entry 33 of list 3.
Undoubtedly.
And the object of Parliament of the framers in putting it in entry 53 was, notwithstanding the declaration under entry 52, the states will still have power in respect of trade, commerce, production, supply, and distribution.
Right. I'm not, before we come to any conclusion.
Entries 26 and 27,
Can get
Man,
continued.
advisedly, they are not made subject to entry 52.
Not made subject to.
Subject to 33.
They are only subject to 33 and 24 is subject to 52, not 26 and 27. They are independent entries. So if the parliament wants to take over anything pertaining to the trade and commerce, supply and distribution, then it has to pass some law under 33. Now, the other correction which I may be permitted to make is,
What is your, now we've seen the entries.
no,
Broadly,
there are two broad arguments. No? One is,
what is the
Yes,
theoretical
yes.
structure that you are
now
creating?
first we say, Lord,
Anything else you want us to, let's complete the entries
yes. Then kindly have
Eight.
entry 6,
of
list 2. Public health and sanitation, hospitals and dispensaries. Omit the rest, not take public health into consideration. And then 8. Word is word intoxicating liquors. Now that is to say is an illustration of what follows. That intoxicating liquor, in relation to that, production, manufacture, possession, transport, purchase, sale of intoxicating liquors. The question is, what is the term intoxicating liquor stand for? And this term has a abundant legislative history, which we call the legal sense. So the question is, when the lordships are considering this term, my request would be the lordships will have to place the lordships in the position of the framers and see how they saw this term at that point of time. What the law was, what was the legal history, the legal sense. It is not always that in terms of the legislative power, lordships have relied upon the popular and the common sense point of view. Because more often than not, the entries have entirely different.
any other entries that we have missed, or that's now the sum total?
Yes. Now, Lord, the next entry in the state list, which I would pray lordship may have, apart from what lordships have seen, entry 51 list sites. It says, what? Duties of excise on the following goods: manufactured or produced in the state, and countervailing duties at the same or lower rates on similar goods manufactured or produced elsewhere in India. So duties of excise on the following goods: A, alcoholic liquors for human consumption.
Is it same as intoxicating liquor?
That's the question which lots of people have to deal with.
Right.
Because why would framers use different words in two different entries? And the reason my answer is the legislative history is there, that is why.
Is there any liquor which is not intoxicating?
I don't think so. At least I have not experienced.
Depends on the consumer, I suppose.
Just come from Holi, so you have
It
to.
depends on the person who drinks it, whether it is
And how,
intoxicating or
how
not.
late?
That could be strength of the, not
What
the
is
effect,
the
but
drinking capacity
effect will be
of the
there.
consumer?
Alcoholic liquors, they all
We have
liquids
no idea.
containing alcohol, they are intoxicating. I can't imagine of a liquor which is not intoxicating. Be it industrial alcohol, alcohol intoxicating means alcoholic content. Industrial alcohol has higher alcoholic content, that's all. It can't be had as it is, but then do we have whiskey as it is? No, we have it with soda or water normally.
That again,
That again depends. Regarding any.
Praise, we must say.
No, for that matter, not some people do have neat liquor, but then, but the neat, that's what I'm trying to explain. No? The neat liquor is also not more often than not mixed with ice cubes. It's not a constitutional issue. No, but it has been not. Kindly have Article 47. Kindly have Article 47. It says state can prohibit consumption of alcoholic drinks. So whenever they refer to beverage form or something that can be had as it is, neat as not just there, Article 47 refers to that as intoxicating drink. So a whole lot of different phrases have been used in different entries. Not there has to be some purpose behind it, and that is what my endeavor would be to show why. But in any case, Lord, at least one assumption I can make is, Lord, when we read entry 51 list 2, when it says alcoholic liquors for human consumption,
There is
that
one
can-
reason possibly why they said, otherwise liquors would have been sufficient. Why do they use intoxicating liquor?
I'll ask that is a question which legal history, not legal, the state of law, which not preceded our constitution,
As Mr.
that indicates.
Mr. Datar will tell you if you go down south, or Mr. Giri will tell you that even when somebody serves you coffee, they'll ask you, do you want to have the liquor? When you have the coffee liquor, it's not the decoction. The decoction is very often referred to as a liquor, but it's not intoxicating liquor. Tea liquor,
Yeah,
absolutely. Tea liquor, coffee liquor.
Each has its own risk. Is made, the coffee powder is mixed with different proportion. It has been carried on from
So it's liquor, but it's not the intoxicating liquor. Therefore, we have a history in our country of alcohol. It's not alcohol, but it's still referred to as liquor.
Not when we're talking of whiskey and liquor, Lord, the coffee liquor seems to be a little. No, coffee liquor is a different. I know.
Coffee liquor is very different.
I know.
Liqueur,
That is
UER.
L-I-Q-U-E-R.
UER.
liqueur it's called sometimes.
Yeah, spirits. It is spirits.
My real problem in this matter is what is the learned Attorney General going to argue when you people are done? See, because
But the bigger problem would be what most of the lordships would do, Lord, without understanding what liquor is.
That's true, that's true.
That would be a bigger problem.
the attorney's whole argument is going to be purely theoretical.
Or if,
can argue the coffee part.
Attorney, you have an uphill task.
no, let him have liquor, Lord, he'll conquer the hill.
The lighter side again.
Actually,
I was appearing.
Look at other way
Chief
around.
Justice Datu.
some of
the
us would
Kerala
like,
High Court.
can do it more impartially. We know nothing about liquor.
On
Can
a
be more
sales
impartial.
tax on hatcheries. So then the question was about 301, 304, etc. Chief Justice Datu asked me, Mr. Venkatramani, how much should you know about chickens? So I said, I don't know about the internal motion, but I know about the motions from state to state. So that was talking about coffee, the Kumbakonam degree coffee, which is the highest
Yes.
coffee. Yes, yes, yes. There's a very important question. Liquor other than intoxication and intoxicating liquor.
That's it.
Therefore, that's the secret of entry 8. When the address your lords on that.
Tony doesn't sound very convincing with regard to coffee liquor, Lord. He must graduate on to the liquor part.
Yes, Mr. Bedi.
Now coming back, Lord, to the, kindly have, Lord, the Lordship has seen, it's a taxing entry, entry 51 list 2, and duties of excise, which means tax on production and manufacture. Now the, Lord, the parallel entry is there in the union list, entry 84. Lordship would have to see it before the amendment because now 2016, GST, etc., has really spoiled the shape of the entries. Pre-2016. It would be there in the footnote. Perhaps.
Yes, we got it in the footnote. You have to thank Mr. Shankaranarayan for producing this masterpiece. No, at page 471.
Yes. Now kindly juxtapose this entry 51 with entry 84, the parallel of this entry in the union list. Because for tax purpose, it seems framers divided this entry. Alcoholic liquor for human consumption and alcoholic liquor not for human consumption. So liquor was divided into two categories. Now, coming back to entry 51 again, Lord, with due respect, Lord, I'm sorry, there was something which I should have pointed out earlier. It contains three items, in fact. Your Lordship would see alcoholic liquors for human consumption, that's one item. The other item is opium, Indian hemp, etc. And the third item is medicinal and toilet preparations, which are in the exclusion clause, but not including medicinal toilet preparations containing alcohol.
So all these cough syrups which have alcohol will go to the center.
For tax.
For tax.
For tax. But the interesting part which I wanted to really emphasize here is, Lord, there is no regulatory entry in any of the lists, either specifying the word industrial alcohol or stating alcoholic liquors not for human consumption. There's no legislative entry in any of the lists, list 1 or 3.
So does it mean that industrial alcohol is not meant for human consumption?
Obviously, it can't be had because the
Nature of-
strength of the liquor is not 95%, 97%, not 90 to 95%.
Yes.
So which is dangerous for health, perhaps.
Mr. Dwivedi, you just said no regulatory entry in any list using the phrase industrial alcohol or I missed actually.
Or alcoholic liquor not for human consumption. I can understand, but if the idea was to regulate these two, tax these two, then there should be some regulatory provision somewhere. Intoxicating liquor is one such entry, Lordship may keep it in mind. But apart from that, there is no entry to regulate industrial alcohol or alcoholic liquors not for human consumption. And more importantly, Lord, if Lordship would see medicinal and toilet preparations containing alcohol, there is no legislative entry in any of the lists. And the question, therefore, which comes to my mind, which I raised before Lordship, and I try to answer that. Why? Taxing entry only regulates part of it, the intoxicating liquor or alcoholic liquor. But the rest of the parts are where we don't know. We have to speculate. Synthetics puts it in entry 52 because of IDR. Now, if we put it in entry 52, then obvious thing would be that it goes to entry 24 then. Because you can't pick up from any other entry excepting 24, so far as industry is concerned. So if we place it in entry 52, then per necessity it must go to entry 24.
But medicinal preparations containing alcohol will go to list 1,
No, but which entry?
entry 97.
No, I'll answer that. No, that's not. If entry 97 has been determined to be so huge, then what was the point in having these entries? They could have just said list 2 and 3, entry 97.
But
it would have included everything.
But a medicinal preparation containing alcohol,
Man.
then the duty of power to levy duty of excise, where will that go according to you?
No, duty of excise is there, entry 84.
Right.
Entry 84, list 1,
Right.
it clearly includes
Include medicines.
unamended. Answer. It includes. So that's what I'm saying, Lord. The idea is to have these items as separate items, but for tax only, but not for regulation.
So entry 84 will cover medicinal preparations which have alcohol.
For taxation.
Act, of course, yes.
So what appears apparently is that unless we look into the legislative history of this word intoxicating liquor and the laws pertaining to alcoholic liquors.
Now we have seen the entire gamut of entries, right?
Man.
Now why don't you formulate what your points are?
Yes.
So then once we do that, we'll go to synthetics and see. It's not a very long matter.
No, it will. We'll have to trace the legislative.
Obviously, but why don't you formulate it?
I would not be able to make it.
No. Obviously, we'll look at the legislative history of intoxicating liquors. But now you can just formulate what your submissions are.
Yes. The first question again is, as I pointed out,
We've made a note at page 29, page
29,
30,
yes.
PDF page 30. But now why don't you formulate what your points are?
not the first question which I'm going to canvass for Lordship is that entry 8 list 2, which confers exclusive jurisdiction on the states to regulate industrial alcohol,
Which confers exclusive.
jurisdiction on the states to regulate industrial alcohol, because industrial alcohol is part of intoxicating liquor. So the scope of entry 8.
Industrial alcohol is part of intoxicating liquor.
Liquor, and therefore states have exclusive jurisdiction.
So your first submission is entry 8 of list 2 confers exclusive jurisdiction on states to regulate industrial alcohol because industrial alcohol is part of intoxicating liquor. All right, what-
Intoxicating liquor, Lordship, note it down. The intoxicating liquor is a general term,
Yes.
unlimited. It has not been restricted by any phrases before or after,
Is a general term.
unrestricted by any other entry, unlike 24. To put it in a better formula, it's a specific entry. Industry is a general entry. This is a specific entry which at least 3 constitutional benches of lordships have held that to be.
Because intoxicating liquor is a general term unrestricted by any other entry.
And perhaps not, it's a special entry in state list as compared to entry 24, which is a general entry. Industry can include any industry. But if Lordship would see entry 8, it says production, manufacture, sale, purchase, everything is there. It includes virtually every activity relating to intoxicating. And in McDowell's case, lordships have held this very clearly that it's a special entry as compared to industry, which is a general entry. For instance, Lordship may have a look at, I'm sorry if Lordships are going, entry 25 list 2. If I may place, no? Entry 25 list 2 says gas and gas works. That's an industry. But the question which I am posing is, does it fall under word industry then? If there is a specific entry which has been carved out of the word industry, entry 24 cannot be deemed to include gas and gas works. In that sense, even Because if industry was wide enough to include gas and gas works, then what was the point in having there? We can't, by interpretation, make the entry redundant. Likewise, entry 8, it's a special entry as compared to the general entry industry, entry 24.
But every other place, they say.
The power to legislate on
Industrial
on industrial alcohol.
Because that is to say, kindly have not the elaborateness of the illustrative part. That is to say is an illustrative word, but look at the elaborateness of the illustrative part. It says,
Industrial alcohol.
production, manufacture, possession, transport, purchase and sale of intoxicating liquor. What else is left then? Apart from this, I ask myself. It's a complete entry, which includes every aspect of industry, intoxicating liquor. So I have to answer that question whether intoxicating liquor is white or not.
No, the question is whether intoxicating liquor would include industrial alcohol.
Industrial alcohol.
That is the question.
That's the question. Yeah. And for that, one of the aspects which I had indicated and emphasized.
Wouldn't it postulate something which is for human consumption by its very nature?
No, that's one way of looking at it. As I said, this is an entry which is general and uncontrolled. Now, intoxicating can mean causing intoxication to the humans.
Yes.
It can also mean a liquor which contains intoxicating element, which can cause intoxication. So to confine this entry to only that aspect that it may cause intoxication to humans when it is had as it is, as a drink, intoxicating drink. Kindly have Article 47 for a
But
moment.
the purpose of industrial alcohol is never to intoxicate. Industrial alcohol is a completely different.
I'll answer that question. It is.
The ordinary use of the article must be seen.
Not the term industrial alcohol.
It's also evident from entry 84.
Let us not confuse the two things. It may not be fit for human consumption as it is. This is not this difficulty. But to say that it is not intoxicating, that is not correct. Because it has alcohol. It has high quantity of alcohol. Therefore, it is intoxicating. We are attributing this term intoxication to humans only. That may not be correct. Considering the wide entry that it is, and a general entry which is unrestricted. Because if it was only human consumption, then entry 51 explained it. So why use the different phraseology? The phraseology would have been there in entry 8. Alcoholic liquor for human consumption. That is to say, framers would not use two entirely different phrases for denoting the same thing. That's one aspect which I have. And I will show.
Because if you see entry 84 clause A as it then stood, duties of excise on tobacco and other goods manufactured or produced in India except A, alcoholic liquors for human consumption.
Right.
There only the state can levy.
Levy duty.
Yes.
So again, the phrase is alcoholic liquor for human consumption. Now, my question to myself is that if alcoholic liquor for human consumption was a set phrase used by the framers to denote alcoholic drinks or beverage form, or which can be had by the humans, then the same phraseology should have been there in entry 8, if the idea was to indicate the same thing. And there is a reason why it is not so, because, as I said, legislative history is very critical in this regard.
Because one
Article
way of
40
looking at it is, if it is a declared industry,
Ma'am,
then obviously the state will not have any jurisdiction with regard to it.
there's
Then
one,
only the center can
no
have the
difficulty, no,
jurisdiction
but
over that entity.
there's no difficulty. But the question which I had posed before Your Lordship was, if intoxicating liquor falls under entry 8, then it is not an industry under entry 24. And if it is not an industry under 24, then it cannot be taken over under IDR. Because then the parliament would be determining the scope of the legislative entry.
We have entry 24, which says in list 2, industry subject to the provisions of entry 7 and 52 of list 1.
So therefore, word industry cannot include word intoxicating liquor, manufacture of intoxicating liquor, because both are separate entries specified in the state list only. One is special, the other is general. The special has been carved out. For instance, as I cited the example of gas and gas works. The Lordships would recall Calcutta gas case, no? But the Lordship specifically said it's a special entry gas and gas works. Intoxicating liquor,
Vedi, I've formulated your third point like this. Entry 51 and entry 54 of list 2 use the expression alcoholic liquor for human consumption.
well,
Entry 8 of list 2 you would have used the same phrase if the framers so intended. But entry 8 list 2 uses a wider phrase, namely intoxicating liquors.
right.
If intoxicating liquor falls under entry 8 of list 2, it does not fall under entry 24 of list 2 and is therefore not subject to entry 52 of list 2.
Union cannot drag it to list 1.
That's your...
Yes.
So really speaking, I think what we now have to focus on is, what does the Constitution mean when they use the expression intoxicating liquors? And let's look at the legislative background of the use of the expression.
Man.
Because, Mr. Dwivedi, then everything really either your argument either falls or survives on the content of entry 8.
Yes.
Does
but
entry 8
there's one part.
intoxicating liquor include as industrial
Absolutely correct.
alcohol?
That's right. Lord. But the alternative argument is that even if industry is the second question which I'm formulating is that even if word industry includes industrial alcohol,
Even if industry
word industry includes industrial alcohol.
in entry 52.
But first it has to include in entry 24.
Right. So alternatively, even if industry in entry 24,
Then only it can be taken over under
right,
entry
right.
52.
No, we were formulating it.
Yes.
We want to understand your
Quite.
alternatively.
But
even
if the
one second,
industry,
let's
I'm
just
sorry.
hold us the thought down, you know.
I'm sorry.
Alternatively, even if industry in entry 24 or entry 51,
52 list 1,
52 of list 1 includes
industrial alcohol.
industrial alcohol, then
Whatever goes to in list 1 is the manufacture.
what?
Manufacture of industrial alcohol. And once the industrial alcohol as product of the notified industry emerges, it goes to entry 33. The product is not included in entry 24 or 52.
So what is included in industry and not the product, that's what you are saying.
Not the product. But it has been well defined. There are at least 7 constitution benches which say word industry only denotes manufacture. It does not include trade, commerce, or production, supply, and distribution. Word production has been not, I would suppose not out of caution, it has been used over, but manufacture goes to industry.
Actually, so even if we reject your point on
One.
intoxicating liquor covering industrial alcohol,
The second,
the alternative limb, which frankly appears to be more acceptable, the alternative, of course,
But if Lordship
but
would
you may
see
be
the whole
right
thing,
because we have not looked still at the legislative history. So we'll do
if
it with an
Lordship
open
would look at it in the sense of a timeline, Lord, perhaps not the alternative may appear to be the easier one to go to and decide.
something which is pending for 14 years, there's no timeline. We have to look at both aspects. But therefore, your second limb is that even assuming it's industry within entry 24 and therefore under entry 52, only the manufacturer falls within entry 52 of list one.
Product goes.
The rest of the product is governed by entry 33. And if it falls in entry 33, then you can levy fees.
The
Under-
jurisdiction doesn't arise, Lord.
Right.
Jurisdiction of state doesn't arise. Jurisdiction is there.
Because you can levy fees then. Fees in respect of any of the entries
Not,
contained.
once your lordships come to the conclusion about the jurisdiction part, then what can be the ambit of jurisdiction is a separate issue, which that can be adverted to, and the disputes will arise. They can keep on coming off and on and can be answered. But the issue is of state's jurisdiction, whether it is there or not, to regulate and control industrial alcohol. Now, in another interesting aspect here would be, Lord, we have Lord, if I may answer here, Lord, I could overhear. It's coming there. Now, Lord,
So these are the four submissions or the alternate
the
submissions?
B part of that last argument is, no, that state will only have jurisdiction if the field is unoccupied
Under NT 33.
and under NT 33. So the Article 254 comes in. And we have expressly stated that till date, there is no legislation by the union because under the IDR Act, not Section 18G is there. If I may place that, no? Lordship may have a look at it. But this would be the last limb. Section 18G of the IDR Act.
So what is the submission? Section 18G, how do you formulate it? Then we look at it.
Section 18G confers an enabling power on the union to regulate the products of the notified industries. For securing equitable distribution and availability at fair price, they can regulate. And that regulation has to be through an order issued by the central government, a notified order. It's like a control order. The union has to regulate by a notified order providing for
Let's see
regulation.
Section 18G, we've got it on the screen here. It will
Yes.
be on the screen here. Yes. Section 18G is in volume 4, page is yours, a PDF page, 577.
Now, this section 18G is traceable to entry 33, list 3. The central government, so far as it appears to it to be necessary or expedient for securing the equitable distribution and availability at fair price, or any article or class of articles relatable to any scheduled industry, may, notwithstanding anything contained in any other provision of this act, by notified order, so may by notified order, provide for regulating the supply and distribution thereof and trade and commerce therein.
So it has to be a notified order.
There has to be, because if I recall correctly, I missed it, but I'll get hold of it inside. Because Lord Chief Justice has in one of the judgment 254 has said there has to be in fact an order there. It has to be real conflict. It has to be actual conflict, not supposed conflict that in future order may be issued and then conflict may arise. So there has to be a real conflict, actual conflict before jurisdiction can be taken away. That's in the case of context of occupied field. The field is occupied only when there is an order under 18G. Oh. As my friend rightly says, not that under 254, state can still legislate and get the presidential assent, should override them.
Yes.
But that's a different issue. I will not. But then that is, at least that indicates that the field has to be actually occupied.
And there is no notified order by
There is, at least I could not discover any notified order. My friend has also asserted that. And in response to in their written submission, they don't say that there is a notified order. They say it's not required.
Right.
Samrat, if Lordship would come to my written submission. Lord, may I take Lordships to my written submission? Please.
Academia, yeah.
Now, Lord, there's one provision which I perhaps should have also cited. I forgot to do that one. Lordship, I have Article 47, which also has some bearing on our question. Though this is a non-enforceable article,
Intoxicating the
it does not impose any restriction on the legislative power. But it certainly gives an indication. The state shall regard the raising of the level of nutrition and standard of living of its people and the improvement of public health as among its primary duties. And in particular, the state shall endeavor to bring about prohibition of consumption except for medicinal purpose of intoxicating drinks. So where they wanted to restrict to beverage form, which is had as it is, they use the term intoxicating drinks.
say the question whether he had any
Ticketing things, consumption of.
Consumption.
during
This shows in the beverage form it is there as intoxicating drink in the constitution. The framers recognized it as such. But then equate it with intoxicating liquor, again becomes a little difficult. I'm not,
Now that you've formulated, now let's go to the legislative history and then the few cases you want to cite.
right.
I think
Can
by
we come
lunch,
to
we'll
blood-
be-
to
Mr.
my-
Trivedi, by lunch, we should be done with your submissions, I think. We'll give
I
you
don't-
still about 1 hour and 7 minutes.
I don't think not. It has taken nearly hour and a half not to elaborate on the entries.
But we've now got the gist of the point. Now we
The
just go
judgments are vague.
rapid fire with your, with supporting your submissions.
Lord, I would only request is, Lord, it's an important issue. Lord, then where the rapid fire may lead to leaving out something which is important. And that is what happened. The rapid fire happened in synthetics too. As a consequence of which lots of things didn't come there.
Mr. Dwivedi, the Chief Justice has to always say that, not because it's going to be enforced, but because the clock on the other side constantly stares at us on the face.
At the very initial,
Just sort of.
at the very
pushing
initial
things
stage, I had said, Lord, if Lordship are going to determine the scope of the argument in terms of timeline, Lord, then perhaps I'll have lots of difficulty.
Timelines now, because, you know, there's so much of work and.
Not for
so
such
much of
an issue
pressure of
which
work.
is there, not rankling since 1951. This is an issue decided for the first time in 51. And since then it continued for 38.
The reason for the reference and everything is not because it was so complex or something, but because perceptions change. Our perception of what India is today is very different from the perception which judges had in 1950 or
Let me answer this.
1960. There's a new dimension to states' rights as federalism has progressed.
Yes.
There are a lot of reasons why we continually relook at our judgment.
There are two answers to it. There are two answers.
Go to your written submissions now directly.
Yes, yes, but before that, there are two answers to it. But federalism concept is to my aid. The other thing is, Lord, the evolution takes place, new things are discovered, new things happen. But then what Lordships have said, that the legislative entries must be interpreted in an expansive manner to include the new things and new situations. But that doesn't mean that the old gets lost. The old will be there. Plus, additionally, this will come.
Submissions.
Yes.
And see how you are first and foremost saying that entry 8
Yes.
covers intoxicating
Yes.
liquor. That's the first
Yes.
major submission which you have, and the second is in the alternative.
Now kindly come to my written submissions, page 2, volume 1A. Page. Page 2. Page 2. At the bottom, Lordship would notice there is a word intoxicating liquor under entry 8 list 2. Have Lordship got? It is important to note that the word industrial alcohol, IA for short, is nowhere used in any of the lists. Entry 8 list 2 only uses the phrase intoxicating liquor, which has a rich and deep history, and the legislative practice accompanying it. It is therefore relevant to notice the history behind this phrase. It has been repeatedly held that the legislative entries are fields of legislation, and therefore, Lordship, this principle is well known, not the first principle is well known, so I need not take time. Then the second aspect is also well known. Then the third aspect, the important part in this is that there is a necessity, starts with the context. Contextual interpretation out of necessity starts with historical perspective, particularly the legislative practice. That is what we broadly call legal sense. Now, there is one decision which I really wanted to place before your Lordships, if Lordship would permit. 1959, 1 SCR 379. And the relevant pages are
1959.
59, volume 1 SCR 379. Page 390 to 391. Then 397 to 413. This decision is not 51, 1 SCR is in volume 5B, page 481. 481. PDF page 486, Andrew.
Volume 5D.
5. Now, the reason why I want to cite this judgment is this is not the 5B. Canon Duncan.
On what proposition do you cite it?
Yes. In this case, the real dispute was with regard to tax on sale of goods. So the question arose, what is the meaning of the term sale of goods as understood by the framers or the lawmakers? This was the case under 1935 Act. Therefore, the entry was the same. They said, what is
So
the
what
meaning
did
of
it hold?
Their lordships debated the question whether we should adopt the popular sense or the common sense point of view with respect to legislative entry, or we should adopt a sense which is in conformity with the legislative practice, which they call the legal sense. And eventually, after considering everything and lots of judgments, both US Supreme Court in British matters, Privy Council and all, they came to the conclusion that the real meaning can be derived after looking into the legal history. That is the legal sense, not the popular sense. That's not always correct.
From legal history, yes.
Why?
How this had been used even before the adoption of that entry in
Because what they said,
the Government of
that,
India.
quite right. And what the lordship said, that the lordships would have to sit in the position of the framers
Fair enough.
and see what the law was. In what sense?
Really, I don't think we need to labor that point really.
No.
Let's go.
This is what, but I wanted to rely on this.
Absolutely.
Therefore.
Perfect.
And 51, therefore, Supreme Court SCR, the one above Balsara. This is 1951 SCR 682.
Yes.
This is Balsara versus State of Bombay. Or State of Bombay versus Balsara.
Where do we find it in the volumes? Volume 5B?
Volume 5. 5B.
5B, right?
Five only 5.
5.
Volume 5, page. 1718.
And what does it say? I mean, you can just formulate it for us.
In Balsara, not the question, of course, the case was with regard to potable liquor,
Yes.
but they considered the history of the term intoxicating liquor.
I think Balsara we maybe have to look at.
Yes. They considered the entire history of intoxicating liquor from the British position to Government of India, because Government of India is
Let's
an
go
act
to
of
that.
British
Let's go to
Parliament.
Balsara.
Yes.
I think Balsara we may see, you know.
Regarding portable liquor.
Yeah.
And then they said intoxicating liquor would include all kinds of liquors, including industrial alcohol. No, there is a difficulty. Not I have it in SCR form. Lordships have it perhaps in AIR form.
Now everybody should cite SCR because we have a DG SCR in place now.
Right, right. So I have it in SCR form. Not Lordships have it. Huh. Yeah, I have it.
And with petrol certificates.
Right here.
That is just opposite.
It is 1951.
82.
SCR. 1951 SCR, page 682.
You can load it for us on the DG SCR. You can load it on the screen.
Yes.
So that's the official report.
He has given SCC online.
You've given SCC on that.
And this further went to the extent of saying even medicinal preparations containing alcohol would come under intoxicating liquor.
Which are the relevant paragraphs?
Yes. But actually, I am from SCR, Lord. I can give you Lordship's relevant pages, but I can't give the relevant.
Alright, he just load it for us on our screen so that we can both follow both the. वो कर लो DG SCR कर लो.
Also, we don't have volume.
It has come.
DG SCR. ESCR दे दिया आपने.
The neutral citation. See this behind.
Want us to go to?
Yes, but kindly notice the question here which arose, no? Page 685 and 686. Question is with regard to, obviously, as I said, no, was against the direction of the Prohibition Commissioner of Bombay, no? Prohibiting.
So where do you want us to go to now?
Kindly have the next page, 686. The second paragraph. The act in question was passed by the legislature of the province of Bombay. This was an act under Government of India Act, not 1949 Act, therefore Government of India Act, and the entry was entry 31, which is in the same terms, not as entry 8.
Intoxicating.
page do you want us now? Let's go where they discuss liquor and, intoxicating
That's
liquor.
page 703, man.
Page 703 page out.
That's how it has to.
The High Court has held that the word liquor starts like that. Acha.
That's 39
The
and now
High Court, before that, Lordship, may have a look at the entry. Entry 31 is at page 690. Page 690. Says entry 31 list 2. Intoxicating liquors and narcotic drugs, that is to say production, manufacture, possession, transport, purchase, sale of intoxicating liquors, opium, and so on. We're not concerned with opium and all, but intoxicating liquors was the word they used. Coming to page 703. And this law was claimed to have been made under entry 31, list 2 of the Government of India Act 1935.
Slightly above this is definition of liquor.
Oxford English Dictionary.
Earlier, just slightly earlier, liquor includes spirit of wine, etc. Just above this paragraph, starting from High Court has held.
The High Court has held, yes. The High Court has held that the word, may I?
Paragraph 39 in this. Your defines that.
May I place it? But in the Bombay Act, perhaps there was the definition of the word liquor,
That's it.
which included spirits of wine, methylated spirit, and all liquids consisting of alcohol. Then the answer is given by the High Court, which is page 703. The High Court has held that the word liquor ordinarily means a strong drink as opposed to soft drink, but it must in any event be a beverage which is ordinarily drunk. Proceeding upon this view, the High Court has held that although the legislature may, while legislating under entry 31, prevent the consumption of non-intoxicating beverages and also prevent the use as drinks of alcoholic liquids, which are not normally consumed as drinks, it cannot prevent the legislature the legitimate use of alcoholic preparations, which are not beverages, nor the use of medicinal preparations containing alcohol. This view of the High Court was very strongly supported on the one hand and equally strongly challenged on the other before us, and I therefore proceed to deal with it. Now then the Lordships go to the dictionary meaning. In the Oxford English Dictionary, edited by James Murray, several meanings are given to the word liquor, of which the following may be known. Quoted. Liquor, a liquid matter in a liquid state, in wider sense, a fluid. A liquid or a prepared solution used as a wash or bath and in many processes in the industrial arts. Liquid for drinking, beverage drink, now almost exclusively a drink produced by fermentation or distillation, malt, liquor, liquor brewed from malt, ale, beer, porter, etc. The water in which meat has been boiled, both sauce, the fat in which bacon, fish, or the like has been fried, the liquid produced by infusion. Lordship may omit the rest and come to the next page. Thus, according to the dictionary, the word liquor may have a general meaning in the sense of a liquid, or it may have a special meaning, which is the third meaning assigned to it in the extract quoted above. Vis-a-vis a drink or beverage produced by fermentation or distillation. The latter is undoubtedly the popular and the most widely accepted meaning of and the basic idea of beverage seems rather prominently to run through the main provisions of the various acts of this country, as well as America and England relating to intoxicating liquor, to which our attention was drawn. But at the same time, on the reference to these very acts, it is difficult to hold that they deal exclusively with beverages and are not applicable to certain articles which are strictly speaking not beverages. A few instances, a few instances will make the point clear. In the National Prohibition Act 1919 of America, the word liquor and intoxicating liquor are used as having the same meaning, and the definition states that these words shall be construed to include alcohol, brandy, whiskey, rum, gin, beer, ale, water, wine, and in addition thereto, any spirituous, vinous, malt, or fermented liquor, liquid, and compounds, whether medicated, proprietary, patented, or not, and by whatever name called, containing 1/2 of 1% of more or more of alcohol by volume, which are fit for use as beverage purpose. Having defined liquor and intoxicating liquor rather widely, the Woolstead Act accepted denatured alcohol, medicinal preparations, toilet and antiseptic preparations, flavoring extracts and syrups, vinegar and preserved sweet cider, which suggests that they were included in the definition. In some of these items, we have the qualifying words unfit for use for beverage purposes. But the heading of the Section 4 of Woolstead Act, under which these exceptions are enumerated, the exempted liquors.
Mr. Dwivedi, if you go to para 40, we are in para 44, which says coming now to the various definitions. Middle of that para.
Yes.
If you go to the middle of that para, even if we exclude the American and English acts from our consideration,
Right.
we find that all the provincial acts of this country have consistently included liquids containing alcohol in the definition of liquor and intoxicating liquor.
May I place it, Lordship?
Yes, you can just read from there, even if we.
Lordship was reading. In the Bengal Excise Act, now the first.
No. The para is coming now to the various definitions.
All right. Coming now to the
Middle of that para.
No, I have it. No?
Even if we.
Coming now to the definition.
No, just skip that. Even if we exclude the American and English acts, that's the ratio.
But can we have it from the form, Lord? Because it refers to the local
Not
acts.
necessary. Just the formulation is even if we exclude the American. That's what we are relying on.
No, they were relying upon Indian acts too earlier. Lordship.
That's not necessary now.
Very well.
Just go to even if we. Even if we exclude the American and English acts from our consideration, we find that all the provincial acts of this country have consistently included liquids containing alcohol in the definition of liquor and intoxicating liquor. The framers of the Government of India Act 1935 could not have been entirely ignorant of the accepted sense in which the word liquor has been used in the various excise acts of this country. And accordingly, I consider the appropriate conclusion to be that the word liquor covers not only those alcoholic liquids which are generally used for beverage purposes and produce intoxication, but also all liquids containing alcohol. It may be that the latter meaning is not the meaning which is attributed to the word liquor in common parlance, especially when that word is prefixed by the qualifying word intoxicating. But in my opinion, having regard to the numerous statutory definitions of the word, such a meaning could not have been intended to be excluded from the scope of the term intoxicating liquor used in entry 31 of list 2.
Man. And this is entry 31 is entry 8
Is entry
of the Constitution. Now, Lord, to kind of corroborate this reasoning, if Lordship would come to my written submissions, Lord, I have extracted all the definitions of liquor in the local acts. And these are all of I think 1950.
Anything more in this judgment that you want to, or this is the point you want?
No, that's the point which I want.
All right, then we'll close this judgment now. What is the next point?
No, kindly come to the Lord, page 8 of my written submissions.
All right, we'll go
where I have extracted the definitions of liquor, intoxicating liquor, alcoholic liquor, and so forth. But a lot flows from that. Page 8 of my written submissions. Page 8. Page 8.
Yes.
So these are the backdrops on the basis of which entry 31 of Government of India Act was enacted, and that was borrowed by the Constitution. Page 8 note. First is Bombay Abkari Act 1878. Liquor includes spirits of wine, methylated spirit, which is not potable, it's poisonous. Spirits is defined later on, but I'll show that. Means any liquor containing alcohol and obtained by distillation, whether it is denatured or not. That's the important part. So they were quite conscious of the fact that there is something like denatured spirit, which is not potable. And then section 315, which may have little below that, excisable article, uses the phrase, because excisable article means and includes any liquor or intoxicating drink, as hereinbefore defined. Then note Madras Abkari Act, again note, spirit means any liquor containing alcohol and obtained by distillation, whether it is denatured or not. Then, can you turn over to the next page, 3.9, definition of word liquor. Liquor includes spirits of wine, methylated spirits, wine, toddy, beer, and all liquids consisting of or containing alcohol. Then excisable article. Any alcoholic liquor for human consumption. Now, the distinction is made here from liquor and alcoholic liquor for human consumption for tax purpose. Then this is followed in the next act also, the Bengal Act. Any liquor for human consumption, excisable article, any liquor for human consumption, it follows the same pattern, Lord. And then, Lord, it defines in section 2, intoxicant means any liquor. Lordship may leave the rest, no? Kindly see section 2.14, liquor means liquid consisting of or containing alcohol and includes spirits of wine, spirits, wine, toddy, pachwai, Lordship omit the rest. Section 2.19, spirit means any liquor containing alcohol obtained by distillation, whether it is denatured or not. Then Lord, Bihar Act follows the same pattern. These are around the same vintage. Excisable article, any alcoholic liquor for human consumption. Section 2.14 defines liquor, includes all liquids consisting or containing alcohol. And then spirit means any liquor containing alcohol obtained by distillation, whether it is denatured or not. Then comes more the MP Excise Act, which is same vintage. The same pattern, Lordship would notice. Alcoholic liquor for human consumption, so far as the excise duty is concerned. Liquor, defined Lord, widely, includes all spirits, all liquids consisting or containing alcohol. And the spirit is defined as widely, including denatured spirit also. So spirit is part of liquor, and the denatured spirit is also part of liquor. Likewise, when you come to Punjab Act, 14, which applied to Delhi, Haryana, Himachal Pradesh, and all these. Here there is an interesting thing which comes in now. Section 2.14, liquor means intoxicating liquor and includes all liquids consisting of or containing alcohol. Not to omit the rest, not. Spirit means any liquor containing alcohol obtained by distillation, whether denatured or not. So in other words, even denatured spirit was part of intoxicating liquor. Intoxicating liquor means intoxicating liquor, both are equated. Then, Lord, the same pattern is followed in the Chhattisgarh Act of 1915. For tax purpose, alcoholic liquor for human consumption is used. Section 213 defines liquor. Liquor means intoxicating liquor and includes spirits of wine, spirit, all liquids consisting or containing alcohol. Then spirit is defined to include even denatured spirit. Again, Lord, UP Excise Act of the same vintage follows the same pattern, exactly the same pattern.
So your contention is that all liquid containing alcohol
Was part of intoxicating
is
liquor.
part of intoxicating liquor.
And not only that, Lord, with due respect, Lord, Lordship may see the page 7 of my written submissions. PDF page 8. There is something more to be said. And I'm only basing this on the fact not that we have followed the Government of India Act 1935, which is an act of British Parliament. So therefore, the pattern and thinking would be the same as it was there. And if in 31 that was the concept, then that has to be the same in the Constitution because framers adopted the same. Now, the legislative practice, may I place it? The legislative, page 7, parent submissions. The legislative practice leads us to British position and therefore to laws prevailing therein. License Consolidation Act of 1910, Section 110, Spirits Act 1910, Section 3, 4, 5, and 6. Now, the License Consolidation Act not uses the term spirit as well as intoxicating liquor for licensing. Then these excise acts have come.
Mr. Dwivedi, liquor will include all liquid containing alcohol. No doubt about it. Because when the legislature or the constitution uses the expression liquor, it means all liquid containing alcohol. But when the word liquor is qualified by the word intoxicating, does that make any difference to that?
Exactly. No, this is what I've
Would
tried.
intoxicating liquor also mean all liquor containing alcohol, which would include all liquids containing denatured spirit also? That's your contention.
That's because not every liquid containing alcohol is included as intoxicating liquor. Intoxicating liquor means liquor. Liquor means intoxicating liquor. That is evident from the pattern of these acts. When
No, but liquor by itself would mean any liquid containing alcohol.
That's true.
All right, that from what sorry? Any intoxicant.
But how?
Usually, not what perhaps is pointed out is that perhaps there can be a drug in a liquid form, which may be intoxicating. So therefore, it can be a liquid containing intoxicant. So word intoxicant was wider.
Intoxicating does not mean that it has to be capable of human consumption.
It indicates the potentiality of the item, that there is alcohol in it, and therefore it is intoxicating. It can mean both, something had as it is, as well as a beverage, or as well as liquid containing alcohol, because that is intoxicating. Now, for instance, take the instance of the country liquor. The country liquor is extremely common all around in most of the states and is the highest revenue churner in the states, perhaps. Now, Lord, what is country liquor? If I may place before your lordships that chart we had prepared to explain to your lordships the term intoxicating liquor. हम बता दीजिए. The rectified spirit. Actually, the base is the rectified spirit. He's in the most convenient form. We've tried to explain the process that will help in understanding of the commodity with which we are dealing.
Mr. Dwivedi, can we you are showing us the definitions of the Excise Act, various states. So, as the Chief Justice said, all liquid containing alcohol will come within that state. Now, whether it brings joy to the human, it must bring joy to the revenue. Is that what you are trying to say?
Right. It does bring quite a joy to the revenue, because most of the states which tried to apply prohibition failed and had to reverse their policies. So it is really joyous for the state to have. I mean, and liquor is really flogged as the most revenue-generating device. There's no doubt about it in our country, and therefore every state wants to control it. But the important part is not see. The chart which we have indicated, the process of manufacturing spirit. It is a heavy, dark colored, viscous liquid, molasses, because that's the basic raw material, molasses. It is the heavy, dark colored, viscous liquid produced in the final stage of manufacturing of sugar. And it is the byproduct in the sugar industry and raw material for the manufacturing of alcohol. Now, how does it happen? Fermentation. Firstly, the viscous liquid obtained from the sugar industry is mixed with water and yeast. It is also added to convert the fermentable sugars present in the molasses into alcohol. By the process of fermentation, a saccharine solution is obtained, which is also known as fermented wash. In the fermented wash obtained during this process, only 10 to 11% alcohol is generated in the total volume. Fermented wash is conveyed from the wash backs to the stills columns in closed pipes. In the process of separating ethyl alcohol from the fermented wash, and in this process, various components of the mixture are separated by virtue of their difference in boiling points. During the process of distillation, impurities like acetaldehyde, fused oil, impure spirits, which are not fit for human consumption, are removed. The product comes to be rectified spirit having strength of 91% to 95% after the process of distillation. Now, this is not ethyl spirit or the rectified spirit as we call it. Redistillation. In order to further remove the impurities, the redistillation is done. After redistillation, the product comes to be extra neutral alcohol having strength of 95 to 97% volume by volume, meaning thereby out of 100 liters of ENA, 95% to 97 is alcohol. This distilled liquor can be aged or unaged to produce potable alcohol. For aged distilled liquor, maturation is required. For unaged distilled liquor, no maturation is required. Vodka, gin, country liquor are examples where maturation is not required. This fact clearly shows that the liquor before maturation is also fit for human consumption. Now, the two columns note the maturation. For maturing of IMFL, Indian made foreign liquor, maturation is only to improve the quality of alcohol, and in this process, ENA is stored in the wooden vats for the period of 1 year or 2 years or 5 years, 10 years, 12 years and 18 years, in which chemical changes occur during storage. As the spirit in the container moves back and forth through the wood, the ingredients, including flavoring compounds, are extracted from the wood and carried back into the container's contents on its own. Now, their column is not, Lordship, the rectified spirit which I was talking about. After distillation or redistillation, the extra neutral alcohol becomes fit for human consumption. One is required to add only demineralized water into ENA, having strength of 95 to 97% volume by volume in India. Country liquor is manufactured simply by adding demineralized water essence plus caramel into the ENA to bring its strength to 25%. So you dilute it because it can't be had as it is. It will really burn your intestines. To bring its strength to 25% volume by volume for plain country spirit and to 36% for manufacturing of spice country spirit. For preparation of it, this is important note. Since ENA is fit for human consumption, it is also used for the purposes of preparation of medicines. Lord, nowadays, Lord, what is interesting is to see, Lord, there are liquors of all kinds which are potable, like for instance, whiskeys and vodkas and all. They go up to 72%, 57, 60%, 72%. Recently, I discovered a potable liquor consisting of 92%. So, Lord, as the Lordship said, Lord, as the time passes, new things come in, new concepts emerge. People keep on experimenting. They want the strongest drink possible. Therefore, they get it. The second aspect of it is important. If you also could turn to the page 7 of my written submission. Blood, because there are blended whiskies, there are single malts. Addition of demineralized water, reduction of spirit, dilution. Addition of demineralized water in the alcohol is done to bring the higher strength to lower strength. In the case of Indian made foreign liquor, by adding demineralized water, strength of 90% V by V to 97 V by V is brought down to 42%. And the desired strength as per the norms. Then it is bottled. Not, I need not go into that. Well, the basic idea is to, I'm sorry. So far as page 7. But before that, what the term portability, which is now being used with regard to entry 8. Portability is a not relative concept. Portability can mean not something had as it is, like intoxicating drink. We have a peg of whiskey or a vodka or something like that. That's intoxicating drink and portable. That's one aspect of portability. The other aspect of portability is that you add something to it and you diffuse it and then make it drinkable. How much you want to reduce and diffuse the strength of the liquor is, that is as per your choice.
But it is something which is fit for human consumption. Portable liquor.
Portable liquor can mean both. This is what I've seen. That it is fit for consumption as it is, or maybe after putting in something into it and then making it consumable. That is by
As
dialectic.
opposed to industrial alcohol, we have to.
Industrial alcohol can be used for industrial purpose also,
It's
like
not portable
producing
liquor.
chemicals.
Industrial alcohol is not portable.
As it is not. But then rectified spirit of not 95% or 94%, by just adding water, you are reducing the strength of the rectified spirit and having it.
May not be.
Unless, of course, it is denatured. Denatured means then you are adding an item into it which perhaps makes it nauseous and, of course, poisonous.
Really, the word intoxicating does not really mean that it has to be fit for human consumption.
As
It's
it
a
is.
liquid, it's an alcohol in which, it's a liquid in which alcohol is being added.
Liquid
Because-
containing alcohol.
You're relying on the legislative history, which was referred to in Balsara's case 1. And second, that the Constitution, when it wanted to use related to alcohol fit for human consumption, it did so in entry 84 of list 1 and entry
51 list.
51 of list 2. Entry 8 is designedly only intoxicating liquors, and therefore intoxicating cannot be conflated with fit for human consumption, according to you.
And I may be repeating myself, but after all, lordships have always held in so many decisions that why use two different phrases for denoting the same thing? Once different phrases are used, then obvious intention is that it denotes something different. And so widely different. Now, the other thing which I wanted to emphasize on is, please notice this. Government of India Act comes in 1935, and for the first time it uses the word intoxicating liquor, entry 31. It has entry 40, which again is parallel to entry 51 list 2.
This is okay, no? So the Government of India Act of 1935,
For the first time in India, use the phrase, not in the constitutional statute, the word intoxicating liquor comes in entry 31. And it's in the same form as entry 8. In fact, the framers have borrowed it from there. And at the same time, they use the same phraseology as in entry 51 list 2. Alcoholic liquor for human consumption in entry 40, which is excise duty. Same as 51 list 2.
can you say that again?
Not in entry 40, the same phraseology as in entry 51 list 2, alcoholic liquor for human consumption has been used. When I had placed the local acts as forming the backdrop, surely not the makers of the Government of India Act were aware of those local acts. Their own Liquor Licensing Act, which used the term intoxicating liquor. Their Spirit Act of 1870, which used both denatured as well as And it was used for licensing in the Intoxicating Liquor Act of 1910. I have indicated that in page 7, no? This aspect, page 7 to 8. But an interesting factor which I wanted to bring to your lordship's notice in this regard is this. When Government of India Act Entry 31 uses the same phraseology as the local acts, intoxicating liquor, then obviously it had in mind that intoxicating liquor which was defined in most of the local acts. That has been borrowed in the government, in the Constitution of India. Obviously, it follows the same thing. Now, in entry 8, the word intoxicating liquor is there. They have followed that. In entry 51 or entry 40 list 2 of the Government of India Act and entry 51 list 2 of the Constitution, they have followed the same pattern as in
Entry 84, list 1.
and entry 4. But first, it is entry 51 list 2 in the state list, and then the excluded part goes to entry 54 list 1.
No, entry 84, list 1 as.
I'm
it
sorry,
comes to-
entry 84.
But then
Right.
you see, entry 8, list 2 is not a taxing entry. But entry 51,
not-
list 2 is a taxing entry.
Quite right. So we are not in the, issue is not tax here. Issue is regulatory power, licensing power.
The two are different.
So what I am saying is, again, Lord, it corroborates my viewpoint that taxing entry cannot be used to curtail the,
That we are entitled to levy a tax.
no, I'm not.
You
Not
say
even
that
for-
I'm entitled to
regulation.
regulate under
It's an
entry
equal
88, under entry 8. And as incidental to the regulation, I can impose a fee under entry 66 of list.
Entry 66. I'm not even for a moment claiming that we have a power to impose tax on denatured spirit or perhaps industrial alcohol. No, we don't have. Entry 84 is clear.
Yes.
And there is no taxing entry other than entry 51 list 2 in the state list. So we can't. But it hardly matters. It doesn't make much of a difference because liquor is nothing but a good. Denatured spirit would be a good. It can be taxed as sales tax. Likewise, it is a good. It can be taxed under entry 52. That is entry tax earlier. So it's not that we can't tax denatured spirit or something. It can be taxed in other forms. That is sales tax, entry tax, and other local taxes. That can be done. But of course, state by itself cannot tax it as a excise duty. That power is not available. To say there is no power to tax industrial alcohol is not correct, with due respect. It is correct to say that we do not have the power to impose excise duty on industrial alcohol. That is correct. In fact, after synthetics clearly held in paragraph 86 that the state will not have power to impose sales or purchase tax. Once IDR is there. That had to be clarified by synthetics third case.
Yes.
That it doesn't deal with sale and purchase tax. Therefore, it couldn't be held to be law on that, laying down law on that. So, interesting part what I'm saying is not if the Government of India Act, when it followed the excisable article by specifying the alcoholic liquor for human consumption and incorporated that in entry 40, and it continued to follow intoxicating liquor and put it in entry 31, then obviously they were seeing the difference. And therefore, for separate things, they were incorporating it in a separate phraseology. We can't mix up entry 51 list 2 and say it kind of restricts entry 8 because that's a taxing entry. This is a regulatory entry, and both lordships have held in so many cases separate. So taxing entry cannot color the regulatory entry. Just as regulatory entry cannot lead to enforcement of and imposing of tax. So it would be quite unimaginable to think that the Government of India, framers of Government of India Act and the Constitution partly followed the local laws and they did not follow the local laws in other respect. No, that doesn't make sense. In this,
And
Yes.
complete their submissions.
no, there is also a word called alcoholic liquor in 351 list to lordships have
Right.
seen. Now, alcoholic liquor obviously is very wide, therefore they divided by saying for consumption.
Consumption.
And if we read the definitions in the local acts, note, it contains all liquids consisting of alcohol, which would be alcoholic liquor. So therefore, intoxicating liquor, liquor means intoxicating liquor and contains all liquids consisting of alcohol, obviously means alcoholic liquor.
Now, for instance, entry 54 after the 101st Amendment
Man.
says taxes on alcoholic liquor for human consumption.
Yes.
So state doesn't have the power to tax, not the industrial alcohol. That is, it can only impose tax in respect of alcoholic liquor for human consumption. But that does not, as I said, mean that state cannot impose any tax on industrial alcohol. It can, sales tax. It can, the entry tax. I mean, after all, industrial alcohol is nothing but goods. The entry tax, it says goods brought in for sale and consumption, for use. So it's not correct to say that the entire field of taxation goes.
Let's look at the submissions so that
Yes.
we then conclude that part.
Page 7, note, I was placing. And I would pray kindly permit me to place the entire page, note, and this one page only. The legislative practice leads us to British position, therefore to laws prevailing therein. License consolidation.
Which
PDF.
page number?
The written submission that I was placing, page 7.
6 last 2 lines.
Page number 6, 7, or also in
6 last 2 lines. Registered.
The legislative practice.
I'm sorry, there seems to be some confusion.
You got it. You got your PDF page 7 bottom.
The legislative practice leads us to British position and therefore to laws prevailing therein. License Consolidation Act 1910, as I already told your lordships, it includes the word intoxicating liquor. B. Spirits Act 1980, which includes the denatured spirit. Spirit Act defines spirit very widely to cover both potable and non-potable liquor. Section 3 to 5, 116. It deals with manufacture, distillation, retailing, etc. of spirits, while Licensing Act of 1910 deals with licensing of distribution. Word intoxicating liquor is defined there to include spirit of all kinds, including fermented and distilled. British position is clear that intoxicating liquor includes all kinds of spirits. The later 1910 Act used this term compendiously to include all spirits, all kinds of spirits, while spirit under 1880 Act included liquor of all kinds. Thus, in England, both the terms were understood and used interchangeably. That's what the Lordship would notice Balsara says. It notices these two acts. Then the Government of India Act 1915, section 45, 79 to 81. The devolution rules made under section 45A and section 129 of Government of India Act 1915 distinguish the functions and jurisdictions of local governments and that of the Governor General or the Indian legislature. The subjects have been classified as central or provincial subjects. Part 2 of the Schedule 1 of the rules mentions item 16 as excise and alcoholic liquor. It is around this time and thereabout various state enactments were framed pertaining to the alcoholic liquors. What is important to notice is not right from the earliest position, the local laws, the Government of India Act, and so on and so forth, not the state had the complete control and jurisdiction of intoxicating liquor. Earlier, under the Government of India Act 1915, even the excise duty in respect of entire intoxicating liquor was with the state, which was separated for the first time in Government of India Act 1935, where industrial alcohol was put in the ken of union and potable alcohol in the ken of the state. That was the position, right? And it was in the light of this position leaving the extracts of local laws. Let's kindly come to para 12, page 12.
Page
Page 12.
12.
Page 12 of the not written submissions. Volume 1A. Volume 1A. In all the state laws, word liquor and spirit are defined as including all liquids containing alcohol. In some acts, word intoxicant is used to define liquor as comprising of all liquids containing alcohol. Additionally, in some local acts, liquor means intoxicating liquor and includes all liquids containing alcohol. It is also noticeable that all the local acts were alive and aware of industrial alcohol and denatured spirit being integral part of spirit or liquor. Reading all the above definitions, it becomes apparent that excise, liquor, and spirits have always been part of state jurisdictions, including industrial alcohol. Center did not have any jurisdiction in this regard. The legislatures were always aware of the industrial use of the alcohol, and the local legislatures were dealing with it. Liquor and spirit traditionally included all liquids consisting alcohol, and industrial alcohol is a liquid containing alcohol. There cannot be any alcohol or liquor which does not cause intoxication. Therefore, any liquid containing alcohol would be capable of causing intoxication. It was in this sense word intoxicating liquor were defined. Intoxicating liquor only follows the past legislative history for convenience as part of the settled vocabulary position, which it had come to denote. Then, Lordship, I omit this note. Then on page 14, Lord, I'll just rush through it. No? Page 14, the latter half, Lord, the importance of legislative practice and past history can never be minimized. This constitutes an important aspect of context as indicated above. For determining the scope of legislative power field, one has to have regard to what legislative practice it ordinarily embraces. And these are the four questions, four cases. And then kindly add this case note, 1959, 1 SCR 379, which I had referred to.
Yes.
Janand Karli's case, which says that it is preferable to have legal sense rather than.
Therefore, there would be a dichotomy, if your submission is correct, namely that the regulatory power over industrial alcohol would vest with the states. But insofar as the taxing power is concerned,
that goes to
the taxing power over industrial alcohol goes to the center.
But again, if I may remind Lordship, the difference is when we talk of taxing power, excise duty is not the only tax. It's a tax on manufacture only. But then rest of the tax state can impose, like sales tax, entry tax, and other local taxes.
Yes.
So these are the cases where I had not. But then the important aspect here again is not, let us fall back on the question state, the union claims or the synthetic sales entry 52 is the source of power to regulate industrial alcohol, exclusive power. Then as I pointed out, then that source leads us to entry 24. Now, if industry word includes industrial alcohol and intoxicating liquor not means something else, then it doesn't make, with due respect, not taking the past into consideration, it doesn't make sense. If the power had to be given to the state originally, if the power had to vest in the state under entry 24, then I possibly can't imagine why the framers would have not put it in not entry 8 rather than entry 24, which is a general vague entry to be searched and traced by a lordships not through legal arguments and dictionaries and things like that. I mean, framers had not enumerated the lists in a very carefully planned and perhaps elaborate manner. Why would they commit this kind of a confusion? So therefore not. So therefore to trace to trace industrial alcohol to entry 52 would be absolutely illogical. That apart, Lordship, again, I'll come to what fell from Justice Chandrachud. Why not entry 97? Entry 97 is a residuary entry which is supposed to be used in exceptional.
There's no other state list entry of.
So the first thing we have to see is whether there is a state entry or any entry in the concurrent
list entry or a concurrent list entry.
So if in list 2 and 3 there is any entry which can logically trace this within itself, then entry 97 cannot be used. But then there's another difficulty, Lordship, notice. If the union traces it to entry 52, then obviously for that reason also entry 97 cannot be used. Because then it falls in entry 24. And intoxicating liquor and industrial alcohol would be in entry 24 basically, and it can be drawn over to entry 52. So this again reduces our difficulty for placing it in entry 97. It can't go to entry 97 because it has been traced to 52. And 52 means 24, which means state list.
Entry 24 is subject to list entry 52 of list 1.
Right.
Suppose it is declared industry under entry 52 list 1.
Right.
It can be any industry which is declared by the parliament.
No, that's the difficulty. It can only be that industry which is in entry 24. So entry 24 cannot include an industry, for instance, entry 25. That is also an industry. And I'll cite 2-3 cases on that. That will clarify it. The first decision which comes to mind is Calcutta Gas, 1962.
Now, what is the meaning to be given to entry 52 list 1?
Yes.
That cannot be curtailed on the principle of what is called parliamentary supremacy, having regard to Article 246 of the Constitution.
I'll answer that. But first and foremost, we'll have to demarcate the fields. Now, when we go to demarcating the fields, we look at entry 52 list 1. Now, entry 52 list 1 uses the word industry. There can be a declaration by Parliament with regard to an industry. Now, the obvious question which I would like to answer is, supposing there is no declaration of Parliament and entry 52 is not utilized, then where does this word industry go? It goes to entry 24. So there is an inherent link between entry 24 and 52, and 52 only borrows from entry 24 and not anything else. So when I am placing it in entry 8, intoxicating liquor, then the union cannot take it over because that's the plenary jurisdiction of the state independent of entry 24.
That too, really speaking, your submissions boil down to 2 limbs. First limb, that industrial alcohol falls within the ambit of entry 8 of list 2. If it falls within the ambit of entry 8 of list 2, it's a specific entry dealing with intoxicating liquors. Therefore, it does not fall in entry 24 of list 2. Since it does not fall in entry 24 of list 2, and it is only entry 24 of list 2 which is subject to entry 51, industrial alcohol is not subject to the overriding power of Parliament under entry 52 of list 1. That's
Because
one.
entry 8 is not subject to.
Right. That's one. Second, you say even assuming that industrial alcohol does not fall within the ambit of entry 8 of list 2, then in that event, and assuming, arguendo, that it falls under entry 52 of list 1, section 18G contemplates that there has to be a notified order, and in the absence of notified order, the subject is not within the fold of Parliament, it falls within entry 33 of list 3.
And for this, Lordship is aware of Tikaramji is the famous case, where it says that. Tikaramji, and then from there starting
And a declaration by Parliament under entry 52 of list 1 notwithstanding, certain aspects are taken over, certain subjects which would otherwise fall under entry 52 have been placed in entry 33 of list 3.
Man.
And therefore, the state power to regulate under entry 33 of list 3 will include the power to levy a fee.
Otherwise, the consequence would be, my lord, that all these entries 8, 25, they all will be rendered nugatory and empty by drawing power from IDR Act. Now here we'll be conferring Parliament the jurisdiction to take away not the power, plenary powers of the state legislature, which are not subject to, which are independent powers. So we can't adopt this.
Even assuming that a declaration is issued by Parliament under entry 52 of list 1, notwithstanding that, it's evident from entry 33 that yet trade and commerce, production, supply, distribution comes within entry 33 because entry 33 clause A covers only those industries which are declared under entry 52 of list 1.
Right. And Lord, the other thing is, Lord, if Lordship would see the Calcutta gas is a constitutional bench judgment, not the first case, where they considered this issue and they struck down IDR on the ground that you can't take over gas and gas works.
We'll come back after lunch. Now, Mr. Dwivedi, I think now we can wrap up in a short while because we have made very substantial progress. I think you've understood your point. Lord, now you can show us whatever remains in half an hour or so.
We've made so much of an effort. Kindly give us some more time.
Oh, yes, of course. We'll run.
Pour in our effort, not perhaps.
Yes, of course. We'll look at the case law. We'll run through now your written submission and see what case law needs to be looked at. We have seen the essence of your submission.
I'm great.